Dear Heavenly Father, thank you for this day, and thank you for all the things that you've given to us. Help us to always be grateful to you and for the things you provide us with. Bless the people of this county and bless the people who represent them. Help us to do your will and make good decisions. We ask in your name. Amen.
From the workshop?
No, from the court.
They have, yeah.
Okay, so that's when we vote to approve it.
Motion.
Second.
Oh. Second.
I said.
All in favor?
Yes, I did. Yes. Yeah.
All thing we had today, I always stick financials on the minutes. We don't have none today. So
Say, where are they?
we're doing the
Trying to sneak something by, that's what I thought.
yeah, I mean, it did. We've been at the gym too long with that. It's not longer.
It's just not finished.
Huh? Come on down.
The other one I read was like, oh.
It takes 39 minutes.
34. Could you read no fashion?
Let's get started.
They can't go. Now second that, go get you a water.
Oh, I got the fancy list of that over it.
Bring cups for everybody.
No.
We're gonna sit talking on.
Judge Texas.
Just cover your cough.
First, I need to make you all aware of the changes that I've made since our workshop. At the workshop on Monday, there was a list of changes, and Rhonda has written those up. I don't know.
Teresa was going to put them in.
Are they in your thing?
I think two of the performance bonds we were asking them to do.
That was not decided. I don't have.
I think we decided that.
Decided.
Yeah, we're going to take it out on that because we checked on that and you think we had $1
You were going to check, but now.
I did check on that. The way the ordinance is written, it says May. And we are just tonight here for the ordinance and not for the bid package. So once we get to the bid package and that, if you all have any corrections to make on that, I'll bring that. But I did not fine tune the bid package like I worked on the ordinance.
So the ordinance doesn't have that in there, right?
The ordinance has the May provision. If you'll flip over to the bonds, section 13 on page 24, it says that bonds are suggested to ensure performance. The amounts and types should be determined, and types of bonds should be considered our performance and payment. So it's not mandatory language, it's suggested language.
All right.
But the things that I added and the notes about the corrections from the Monday meeting are not in mine. Are they in your all's packet?
Yeah, we got some here where you took
What
out
does
the
it say?
last.
You got that?
Where you took up the
Yes.
last page of 12 errors, you got took it out, took the whole paragraph out here.
Yes, okay, so it's fine.
So
What I did add in after speaking with the people in Frankfurt, I changed the name of the cabinet on page 1, it's in the environment. On page 18, I changed the reporting requirements that the solid waste collector, who we determine is going to pick up the trash after the bids and things like that, has to make reports to the county for information needed for the solid waste plant. So whoever the franchisor is has to report to the solid waste coordinator. There's new provisions in KRS 224 or something about recycling and how much we take, and it's part of the plan, but there's more requirements that just started this year. If you'll turn to page 19, I also added reporting requirements in the rules and regulations section. So in that, we're asking the franchisor to tell the coordinator who takes their garbage to the facilities and who we're picking up, and then the people who aren't complying with that at a different time. And then registration of all vehicles used. That's what was suggested by Deborah, somebody at the Energy Cabinet. And that was her suggestions on this. So I just want to slide that in for Monday that's not in the corrections. Anybody have anything they'd like to talk or change?
What's the purpose of registering vehicles? They register those with us or
We
just on
register
the
them at
insurance?
the county so that we know what vehicles are. And whoever the franchisor is would have to show a list of vehicles that are operating, that they're using,
In
that they're
the county.
licensed.
Purpose of that, Victor, is so that they just can't send anybody out. It would be a registered hauler, basically. The vehicle is registered with the county and the state, that this is the vehicle that you're supposed to pick up and work.
Right, okay.
You know, can't go around picking up truck.
Like in the event of a breakdown or something, they send another truck out, I mean,
Yeah.
But they'll have all the vehicles.
they'll have all the vehicles registered, okay.
Yeah.
Okay.
Are you all okay with the suggested language of the laws?
The law.
You're saying that we should, as a fiscal court, do that, is that what you're saying?
I'm saying I would
Suggesting to
strongly
us that we do it.
recommend that we have performance bonds.
And if we
The
don't, do it,
language-
bites on the butt, it's our fault, right?
I'm just saying that the language of the ordinance is such that it permits you to, if the court decides not to require that, which would be against my recommendation, that you still have that option. But I believe that's premature right now because I think we need to get an ordinance passed.
I agree.
And then we can look at the bid more specifically.
We can come back to it.
Or we can come back to the bid package. I did not bring the bid package to be read. That was another 40 pages. Oh, yes, yes.
So we have to read the bid package.
I don't know that you have to read the bid package. Do you?
That wasn't my.
I didn't think so. That's it's like when you do the courthouse, you have to publish notices that we're accepting bids and times and dates and things all with that. But nothing. We can cross that bridge later. We're not going to be advertising for bids today at all. We have to pass the ordinance first. Any other thoughts? Questions?
Question, no?
An ordinance regulating solid waste management, storage, collection, transportation, processing, and disposal. An ordinance pertaining to public health, safety, welfare, regulating storage, collection, processing, transportation, and disposal of solid waste, providing a penalty for the violation of provisions of this ordinance, and repealing any and all ordinances in conflict herewith. Pursuant to Kentucky Revised Statutes 224 and 109 and related administrative regulations, Martin County, including its cities, has been designated as a solid waste management area based upon the solid waste management plan approved by the Energy and Environmental Cabinet, herein after referred to as the Cabinet of the State of Kentucky. In addition, Martin County is acting under powers outlined in KRS 67083, which provides the authority for the exclusive management of solid waste by ordinance or contract. KRS 67083 subsections C and R, which provide authority to regulate and manage public sanitation and garbage disposal service. KRS 67083, which gives authority to fiscal courts for conservation, preservation, and enhancement of natural resources, and KRS 68178, which grants counties authority to license off-site waste management facilities. Now therefore be it ordained by the Fiscal Court, Martin County, Kentucky, that this ordinance shall be known as the Solid Waste Management Ordinance. The Fiscal Court or its designees shall be responsible for the administrative management of this ordinance and the promulgation of rules and regulations authorized in Section 7. For the purpose of this ordinance, the following terms shall be deemed to have the meanings indicated below. Agricultural waste. Any non-hazardous waste resulting from the production and processing of on-the-farm agricultural products, including the manures and prunings and crop residues. Approved incinerator. An incinerator that complies with all current regulations of the responsible local, state, and federal air pollution control agencies. Bulky waste. Non-putrescible solid waste consisting of combustible and or non-combustible waste materials from dwelling units, commercial, industrial, institution, or agricultural establishments which are either too large or too heavy to be safely and conveniently loaded into solid waste transportation vehicles. Cabinet. The Energy and Environmental Cabinet. Closure. The time at at which a waste treatment, storage, or disposal facility permanently ceases to accept the wastes and includes those actions taken by the owner or operator of the facility to prepare the site for post-closure monitoring and maintenance, or to make it suitable for other uses. Collection, removal of solid waste from the designated pickup location to the transfer vehicle. Acceptable collection practices shall consist of the following: 1, door-to-door household collection, and or 2, direct access to a staffed convenience center, recycling center, or transfer facility. Collection box, an unstaffed receptacle utilized to collect municipal solid waste. Commercial solid waste, all types of solid waste generated by stores, offices, restaurants, warehouses, and other services and non-manufacturing activities, excluding households and industrial solid waste. Compost, solid waste which has undergone biological decomposition of organic matter, been disinfected using composting or similar technologies, been stabilized to a degree which is potentially beneficial to plant growth, and which is approved for use or sale as a soil amendment, artificial topsoil, growing medium amendment, or other similar uses. Composting, the process by which biological decomposition or organic solid waste is carried out under controlled aerobic conditions, and which stabilizes the organic fraction into a material which can easily and safely be stored, handled, and used in an environmentally acceptable manner. Composting may include a process that creates anaerobic zone with the composting material. Composting does not include simple exposure of solid waste in uncontrolled conditions resulting in natural decay. Convenience centers, a facility that is staffed during operating hours for the collection and subsequent transportation of municipal solid waste. Coordinator, the coordinator of the solid waste management program of the county shall be the county judge executive unless another is so designated by the Martin County Fiscal Court. County, the county of Martin, Kentucky. Demolition and construction waste, materials resulting from the construction or destruction of residential, industrial, or commercial structures. Disposal, the discharge, deposit, injection, dumping, spilling, leaking, or placing of any solid waste or hazardous waste into or on any land or water so that such solid waste or hazardous waste or any constitute thereof may enter the environment, be emitted into the air, or be discharged into any water, including groundwaters. Disposable solid waste container, disposable plastic or paper sacks with a capacity of 10 to 35 gallons specifically designed for storage of solid waste. Dwelling units, any room or group of rooms located with a structure and forming a single habitable unit with facilities which are used or intended to be used for living, sleeping, cooking, and eating. Generator, any person by site whose act or process produces waste. Governing body, a county, a waste management district, an entity created pursuant to the Interlocal Cooperation Acts, a taxing district created pursuant to the provision of KRS 65180 through 65192, a special district created pursuant to the provisions of KRS 65160 through 65176, or counties acting under contract pursuant to KRS 109082. Hazardous waste, any waste or combination of waste which are, because of its quantity, concentration, or physical, chemical, or infectious characteristics, may cause or significantly contribute to any increase in mortality or an increase in serious, irreversible, or incapacitating reversible illness, or pose a substantial present or potential hazard to human health or the environment when improperly treated, stored, transported, or disposed of, or otherwise managed. Household solid waste. Solid waste including garbage and trash generated by single and multiple family residences, hotels, motels, bunkhouses, ranger stations, crew quarters, and recreational areas such as picnic areas, parks, and campgrounds. Industrial solid waste generated by manufacturing or industrial processes that is not a hazardous waste or a special waste as designated by KRS 224868, including but not limited to waste resulting from the following manufacturing processes: electric power generations, fertilizer or agricultural chemicals, food and related products or byproducts, non-ferrous materials, manufacturing foundries, organic materials, organic chemicals, plastics and resins manufacturing, pulp and paper industry, rubber and miscellaneous plastic products, stone, glass, clay, and concrete products, textile manufacturing, transportation equipment, and water treatment. Key personnel, an officer, partner, director, manager, or shareholder of 5% or more of stock or financial interest in a corporation, partnership, or association, or parent subsidiary or affiliate corporation, and its officers, directors, shareholders, or 5% or more of the stock or financial interest. Materials recovery facility, a solid waste management facility that provides for the extraction from solid waste of recyclable materials suitable for use as fuel or soil amendment by any combination of those materials. Multifamily residential unit, a housing facility containing more than one dwelling unit under one roof. Municipal solid waste disposal facility, any type of waste site or facility where the final deposition of any amount of municipal solid waste occurs, whether or not mixed with or including other waste allowed under Subtitle D of the Federal Resource Conservation and Recovery Act of 1976, may be federal, as amended and includes but is not limited to incinerators and waste-to-energy facilities that burn municipal solid waste and contained in residential landfills, but does not include waste site or facility which is operated exclusively by a solid waste generator on property owned by the solid waste generator, which accepts only industrial solid waste from the solid waste generator, or industrial solid waste generated at another facility owned and operated by the generator, or wholly owned subsidiary, or a medical waste incinerator which is owned, operated, and located on the property of a hospital or university which is regulated by the cabinet and used for the purpose of treatment prior to landfill of medical waste received from the generator, exclusively or in combination with medical waste generated by professionals or facilities licensed or regulated or operated by the Commonwealth. Municipal solid waste reduction, source reduction, waste minimization, reuse, recycling, composting, materials recovery. Occupant, any person who alone or jointly or severally with others who shall be in actual possession of any dwelling or unit or other improved real property, either as owner or as a tenant. Open burning, burning of any matter in such manner that the combustion resulting from the burning is emitted directly into the outdoor atmosphere without passing through a stack or chimney. Open dump, any facility on site for the disposal of solid waste which does not have a valid permit issued by the cabinet or does not meet the environmental performance standards established under regulations promulgated by the cabinet. Person, an individual, trust, firm, joint stock company, corporation, including a government corporation, partnership, association, federal agency, state agency, city, commission, political subdivision of the state of Kentucky, or any interstate body. Processing, incinerating, composting, baling, shredding, salvaging, compacting, and other processes whereby solid waste characteristics are modified or solid waste quantity is reduced. Public nuisance, illegal waste disposal practices that include but are not limited to open burning, open dumps, or littering, which are deemed to be a nuisance under applicable law. Recover material, those materials including but not limited to compost which have known current use, reuse, or recycling potential, which can be feasibly used, reused, or recycled, and which have been diverted or removed from the solid waste stream for sale, use, reuse, or recycling, whether or not requiring subsequent separation and processing, but does not include materials diverted or removed for purposes of energy recovery or combustion except refuse-derived fuel, RDF, which shall be credited as a recovered material in an amount equal to that percentage of the received on a daily basis at the processing facility and processed into RDF, but not to exceed 15% of the total amount of the municipal solid waste received at the processing facility on a daily basis. Recovered material processing facility, a facility engaged solely in the storage, processing, and resale or reuse of recovered material that does not mean a solid waste management facility if solid waste generated by a recovered material processing facility is managed pursuant to KRS Chapter 224 and administrative regulations adopted by the Cabinet. Recycling, any process by which materials which would otherwise become solid waste are collected, separated, or processed and reused or returned to use in the form of raw materials or products, including refuse-derived fuel, when processed in accordance with administrative regulations established by the Cabinet, which does not include the incineration or combustion of materials for the recovery of energy. Refuse-derived fuel, a sized processed fuel product derived from extensive separation of municipal solid waste, which includes the extraction of recoverable materials for recycling and the removal of non-processables such as dirt and gravel prior to processing the balance of municipal solid waste into the refuse-derived fuel product. Residential dwelling unit, a building or portion thereof providing complete housekeeping facilities for one person or one family. Residential solid waste resulting from the maintenance of dwelling units. Sanitary landfill, a permitted facility for the disposal of solid waste that complies with the environmental performance standards specified in 401 KAR 47030. Sludge, any solid or semi-solid liquid waste generated from a municipal, commercial, or industrial wastewater treatment plant, water supply treatment plant, or air pollution control facility exclusive of treated effluent from a wastewater treatment plant or any other such waste having similar characteristics and effects. Solid waste, any garbage, refuse, sludge, or other discarded material, including solid, liquid, semi-solid, or contained gaseous material resulting from industrial, commercial mining, excluding coal mining waste, coal mining byproducts, refuse, and overburden. Agricultural operations and from community activities, but does not include those materials, including, but not limited to, sand, soil, rock, gravel, or bridge debris, extracted as a part of the public road construction project funded wholly or in part with state funds, recovered materials, special waste designated by KRS 224868, solid or dissolved material in domestic sewage, manure, crops, crop residue, or a combination thereof, which are placed on the soil for return to the soil as fertilizers or soil conditioners, or solid or dissolved material in irrigation return flows or industrial discharges, which are point sources subject to permits under Section 402 of the Federal Water Pollution Control Act, as amended Statute Book 86-880, or source specials, nuclear, or byproduct material as defined by the Atomic Energy Act of 1954 as amended statute of 68, 923. Solid waste management. The administration of solid waste activities, collection, storage, transportation, transfer, processing, treatment, and disposal, which shall be in accordance with a cabinet-approved county or multi-county solid waste management plan. Solid waste management area or area. Any geographical area established or designated by the cabinet in accordance with the provisions of Senate Bill 2. Solid waste management facility. Any facility for collection, storage, transportation, transfer, processing, treatment, or disposal of solid waste, whether such facility is associated with facilities generating such waste or others but does not include a container located on property where solid waste is generated, which is used solely for the purpose of collection and temporary storage of that solid waste prior to off-site disposal, or a recovered material processing facility which is subject to regulation pursuant to Senate Bill 2 for control of environmental impacts and to prevent any public nuisance. Solid waste management plan. The document submitted by waste management districts, counties, or any combination thereof as required under KRS 224887 and approved by the cabinet. Solid waste site or facility. Any place at which solid waste is managed, stored, treated, processed, or disposed. Solid waste storage container, receptacle used by any person to store solid waste during the interval between solid waste generation and collection, made out of plastic, vinyl, metal, ranging in size from about 10 gallons to 42 cubic yards in size. Storage, the containment of waste either on a temporary basis or for a period of years in such a manner as not to constitute disposal of such waste. Transfer, the placement of solid waste from smaller collection vehicles into large vehicles for transportation to intermediate or final disposal facilities. Transportation, any off-site movement of waste by any mode and by any loading, unloading, or storage incidental thereof. Treatment, any method, technique, or process including neutralization designed to change the physical, chemical, or biological character or composition of any waste so as to neutralize such waste or so as to render such waste non-hazardous. Safer for transport, amenable for recovery, amenable for storage, or reduced in volume. Also includes any activity or processing designed to change the physical form or chemical composition of hazardous waste so as to render it non-hazardous. Waste Management District, any county or group of counties electing to form under the provisions of KRS Chapter 109 and operate in conformance with the provisions of KRS Chapter 109 with Section 4006, Resource Conservation and Recovery Act of 1976 as amended, Public Law 94-580. Waste site or facility, any place where waste is managed, processed, or disposed of by incineration, landfilling, or any other method but does not include a container located on property where solid waste is generated and which is used solely for the purpose of collection and temporary storage of that solid waste prior to off-site disposal or a recovered material processing facility or the combustion of processed waste in a utility boiler. Yard waste, grass clippings, leaves, and tree trimmings. Section 2, storage of solid waste. Section 2.1, storage containers required. Storage containers for residential solid waste are required if bags of garbage are subject to be torn or damaged by animals or otherwise would create spillage and litter. Storage of waste shall be maintained in a clean, neat, and sanitary condition at all times. The containers and their contents must not weigh more than 50 pounds and be configured with handles for ease of handling by one person. The solid waste hauler will have authority to approve or disapprove a questionable container or storage frames. Oil drums will be acceptable for storage of bags only and must have drain holes.
Okay, now what you first read there was all the definitions. Now we're starting to get into the actual ordinance itself.
Wait a second. Page 14.
I'd like to direct your attention to page 14. I've noticed a correction that needs to be made, so you get your plans out. On section 6.2, it says Kentucky Natural Resources Environmental Cabinet. I'd ask that you change that to Energy and Environmental Cabinet. We could make that correction before we head into it. I brought you correction tape also so you can make it
Okay.
look nice whenever you publish it.
Kentucky Energy, Environmental Protection Cabinet.
It's actually, yes, it's,
Take out natural resources.
yes.
Kentucky Energy. Okay.
Sorry about that.
Okay. Section 2.2, commercial storage. Containers for commercial waste generation will be provided by the solid waste hauler so as to be compatible with machinery for collection purposes. They shall be maintained in a suitable manner by the commercial waste generator to ensure clean and sanitary conditions. The cost of containers to the solid waste hauler can be recouped through rental charges to the generator. Section 2.3, standards for residential, commercial, and institutional and industrial use storage containers. All uses which generate more than a volume of 2 cubic yards, approximately equivalent to 500 pounds, or 400 gallons of solid waste per week shall be required to provide bulk containers for storage so as to be compatible with collection equipment and approved by the coordinator. The container shall be waterproof, leak-proof, and shall be covered at all times except when depositing waste therein or removing the containers thereof, and shall meet all requirements as referenced in Section 8. The cost can be recouped through rental charges to the generator. Section 2.4, airtight containers. No owner, occupant, tenant, or lessee of any building or dwelling may leave outside the dwelling or building in a place accessible particularly to children any abandoned or unattended white goods, icebox, refrigerator, or other receptacle that has an airtight door without first removing the doors. Section 2.5, storage containers not in compliance. Solid waste containers which do not meet the specifications as outlined in this action shall be considered waste and may be collected together with their contents and disposed of. Section 3, collection of solid waste. Section 3.1, county responsibility defined. The county shall provide for the collection of all solid waste generated in the county, provided, however, the county may provide the collection service by allowing individuals to self-haul their household waste to a staff convenience center, or by contracting with a person, county, or other city, or in combination thereof, for the entire county or portions thereof as deemed to be in the best interest of the county. Section 3.2, mandatory collection. All generators of solid waste in Martin County shall utilize the collection program provided by the county. Section 3.3, collection points. Points of collection of solid waste shall be from the roadside or curbside within public rights-of-way or other locations near buildings, parking lots, etc. on private property. In general, solid waste generated and stored in disposable containers shall be placed along the roadside or curbside fronting the subject property not more than 12 hours before collection. Residential, commercial, institutional, and industrial uses required to provide bulk storage containers shall be located on private property in areas accessible to the collection vehicles. In the event that there are residences inaccessible to collection vehicles as determined by the coordinator, alternative collection points may be arranged. Section 3.4, bulky items and heavy items. Items too bulky or heavy to put in storage containers will be collected upon request as feasible if arrangements are made with the solid waste hauler provided that the items are of a physical description compatible with conventional collection equipment. Bulky items will be subject to a separate charge because of the special handling and equipment required. Additionally, bulky items may be dropped off by the owner at the approved landfill or convenience centers only during those hours established for that purpose by the operator of the disposal facility to ensure disposal methods will be in compliance with appropriate federal, state, and local law and regulations. Section 3.5, authority for collectors to enter private property. Solid waste collectors employed by the county or a solid waste collection agency operating under contract with the county are hereby authorized to enter upon private property for the purpose of collecting solid waste as required by this ordinance. Solid waste collectors shall not enter dwelling units or other residential buildings for the purpose of collecting residential solid waste. Commercial solid waste may be removed from within commercial establishments upon written request by the owner and approved by the coordinator. Section 3.6, collection frequency. All solid waste other than bulky waste shall be collected at least once weekly. Residential, commercial, institutional, and industrial uses generating large quantities of solid waste may be required to provide collection at more frequent intervals, twice weekly or more, upon determination by the coordinator as necessary for the protection of public health, safety, and welfare. All collections shall be made between 6 a.m. and 6 p.m. Section 3.7, ownerships of solid waste. All waste and refuse placed for the collection shall remain the property of the waste generator, whether it be residential, commercial, until such time as the waste is placed in the collection vehicles. No person shall be allowed to separate, carry off, or dispose of waste and refuse placed for collection, and it will be a violation of this ordinance to do so. Section 3.8, collector's responsibility defined. Solid waste collectors operating within the county shall be responsible for the collection of solid waste from collection points to a transportation vehicle, provided solid waste is stored in compliance with provisions set forth in this ordinance. Spillage or blowing litter caused as a result of the duties of the solid waste collector shall be collected and placed in the transportation vehicle by the collector. Spillage not caused by the collector is the responsibility of the waste generator. The waste generator shall collect and locate spillage at a collection point for the next scheduled pickup. Section 3.9, prohibitions. The following waste shall not be deposited in solid waste containers or receptacles: hazardous waste, liquid waste, bulky waste, major appliances, furniture, tires, construction, and demolition waste, dead animals. Any burning or smoldering materials or any other materials that would create a fire hazard, batteries, and any other items designated by the cabinet not proper for solid waste landfills. No unauthorized person may remove any item from a solid waste receptacle climb on or into a container or receptacle, or damage any container. Section 4, transportation of solid waste. Section 4.1, collection vehicle standards. All commercial transportation vehicles shall be maintained in a safe, clean, and sanitary condition and shall be so constructed, maintained, and operated as to prevent spillage of solid waste. All vehicles to be used for transportation of solid waste shall be constructed with watertight bodies and with covers which shall be an integral part of the vehicle or shall be a separate cover for suitable material with fasteners designed to secure all sides of the cover to the vehicle and shall be secured whenever the vehicle is transporting solid waste, or as an alternate and entire bodies thereof shall be enclosed with only loading hoppers exposed. No solid waste shall be transported in the loading hoppers. They shall be cleaned as often as necessary to prevent a nuisance and insect breeding and shall be maintained in good repair. Section 5, disposal of solid waste. Section 5.1, open burning. Open burning of solid waste, hazardous waste, tires, or bulky waste is prohibited as defined by KRS 224005 and KAR 63005. Section 5.2, open dumping. Open dumping of solid waste, including bulky waste and tires on all lands, roadsides, hollows, rivers, streams, lakes, etc., by any person is prohibited by KRS 224835 in this ordinance. Section 5.3, disposal sites. All solid waste, including bulky waste, shall be disposed of within a sanitary landfill having a valid permit issued by the Cabinet in compliance with KRS 224830, 224835, and 224855 in this ordinance. Section 5.4, hazardous waste. As defined within this ordinance, hazardous waste is required special handling, will require special handling, and shall be disposed of only in a manner authorized by state or federal regulations. No hazardous waste defined as from a small quantity generator or radioactive waste defined as below regulatory concern shall enter the solid waste stream intended for disposal in the county unless such waste is identified to the coordinator as to its specific source, composition, and quantity. Section 6, sitting requirements, siting requirements. Section 6.1, license requirements. No one shall engage in business of collecting, disposing, transporting, or processing of solid or special waste within the county without a license secured from the governing body. In the event that any one person engages in the collecting, disposing, transporting, or processing of solid waste or any combination thereof as one operation, only one license shall be required. Section 6.2, license application. Each applicant for any such license shall provide the governing body with all information that is required to provide to the Kentucky Energy Resources and Environmental Protection Cabinet, the U.S. Environmental Protection Agency, and/or any other state or federal agency to obtain necessary permits for said operation. The following also shall be provided to the governing body and not contained in the information provided above. A plan for presenting the proposal to the public, answering public questions or concerns, working with the public or the governing body to address any concerns and make modifications in the proposal if necessary to address those concerns, and for the providing public access to all pertinent and relevant information and records both prior to and during the operation of the facility. Compliance with any local zoning or land use ordinances or planning. Details on the exact location of the facility or service, ingress and egress to the site, any site modification required, and transportation plan. The transportation plan shall include information on the volume of traffic to be generated by the facility or service and a statement of the impact of this traffic on the immediate neighborhood, the county's general traffic situation, and the condition of the roads. A willingness to abide by any and all orders issued by the Martin County Department of Health. A reutilization plan for the site after closure of the operation. A plan for keeping the site keeping the site clean and free of debris and aesthetically acceptable to the citizens of Martin County to minimize mud, dust, noise, and to provide a buffer with neighboring residences or businesses if necessary. The proposed days and hours of operation, proof of adequate insurance for general liability purposes, and any and all other information that the governing body may deem necessary to determine the consistency of the proposed operation with the goals and objectives of the county solid waste management plan and to protect the general health and welfare of Martin County and its citizens. Section 6.3, incinerators and landfills. In addition to the above information, all applicants to construct or operate an incinerator or landfill for solid or special waste shall provide the following: extensive and detailed information on all owners, investors, partners, operators, managers, and other key personnel, including those of companies that will provide services to the license holder, such as transportation, engineering, or other services key to the operation of the facility. That includes the following: their interest or level of investment or role in the operation, past or current investment or involvement in similar or related businesses or operations, history of environmental violations, fines, and citizens' complaints related to each individual, as well as their past investments or involvements. Statement of qualification for key personnel and financial statements showing the financial stability of the owners and operators, and a detailed capital project budget. A statement as to how the operation may affect property values within a 1 mile radius of the proposed facility or operation as well as along all transportation routes. Statement of assurance that the physical and biological environment of Kentucky's blue line streams are not adversely affected. A plan for monitoring service and groundwater quality with area potentially affected by the facility or operation and for immediate corrective action or cessation of operation upon detection of adverse patterns or impacts upon these water resources. Plans to provide resources for and to involve the general public in ongoing and independent inspection and monitoring of the facility or operation. Plans for making waste reduction and recycling an integral part of the operation. Plans for providing resources for the long-term independent monitoring of the facility and the site for a period not less than 30 years after its closure, and for setting aside sufficient resources adequate to pay the costs for remedial or cleanup activities from a worst-case scenario. A community impact statement that shall consider all reasonable community and environmental impacts, including but not limited to air and water, condition of soils, historical and archaeological long-term land use of the site and adjacent properties, transportation, economic development, tourism, and social impacts. Any and all other information that the governing body may deem necessary to determine the consistency of the proposed operation with the goals and objectives of the county solid waste management plan and to protect the general health and welfare of the Martin County and its citizens. All information provided to the governing body under this section shall also be made available for public inspection at a place and during hours that are convenient to the public. All technical information shall be written in such a way that can be easily understood by the general public. Section 6.4, license issuance. The applicant must provide at least 3 copies of the above information to the governing body along with $100 application fee. This fee may be waived for nonprofit organizations or those engaged in recycling activities. At the same time, the applicant must provide adequate public notice that it has submitted an application to the governing body. Said notice to contain a reasonable summary of the proposed operation or facility and locations and times where the above information can be inspected. On receipt of the application, the governing body shall begin a review process that emphasizes public participation. The governing body shall provide adequate public notice of the time and place and purpose of the meetings at which the application shall be reviewed and shall solicit and encourage public comment on the application. Once the application is received and deemed complete, the governing body shall adhere to the following timetable for issuing, denying a license. Recycling facilities, 30 days. Transfer stations for solid waste, 60 days. Incinerators, landfills, or transfer stations for special waste, 150 days. If the governing body is able to determine that the applicant can and will construct and or operate the proposed facility or service without creating a nuisance or hazard to the public health or damage to the environment, in conformity with this and all related ordinances and regulations, state and federal laws, then the governing body may issue the license authorized by this ordinance. The license shall be issued for a period of 5 years, providing the license holder submits at least annually an oral or written, if requested, report to the governing body on the condition of the operation and any changes or updates in the information required above as part of the license application process. Section 6.5, license suspension. If the Martin County Department of Health, state or federal agencies or independent inspections determine that the operation poses or is causing significant threat to public health or the environment, the operation shall cease until such situation is correct. If the operation fails to take corrective action, the governing body may revoke its license. Section 7, franchising. Section 7.1, franchise requirement. No person may engage in the business of solid waste collection unless he holds a franchise issued by the County Fiscal Court or its designee authorizing him to or her to collect, transport, and dispose of solid waste and describing the area for which the franchise is issued. 7.2, establishment of a franchise. The county shall determine the area for which franchise is granted. Section 7.3, granting franchise. The county shall advertise and seek proposals to serve each franchise area. Application for franchises shall be filed with the court on forms prescribed by the coordinator. The board may grant a franchise only upon findings that the applicant will render prompt, efficient, and continuing service to the area for which the franchise is granted, and that the applicant has sufficient equipment and personnel to render service to all persons generating solid waste within the service area. A franchise shall be granted for a term of 4 years and may be renewable. No franchise shall be assignable. Section 7.4, fee approval. The Fiscal Court and or its designee shall approve all fees charged by solid waste collectors. Fee schedules may be requested annually. 7.5, termination of franchise. A solid waste collector granted a franchise under this ordinance shall give 90 days written notice to the county before abandoning the franchise. The county may terminate or suspend all or any portion of the franchise for failure to comply with any provision of this ordinance, failure to render prompt and effective service, or failure to comply with authorized fee schedules. 7.6, reporting requirements. A solid waste collector shall provide any and all reports to the county containing such information as is required by the solid waste coordinator. Section 8, rules and regulations. The fiscal court and/or its designee shall make, amend, revoke, and enforce reasonable rules and regulations governing but not limited to preparation, wrapping, and drainage of garbage deposited in solid waste containers, specification for solid waste containers including type, composition, equipment, and size, shape thereof, identification of solid waste containers and of the cover there and equipment thereto appertaining, if any, weight limitations of the combined weight of solid waste containers and the contents thereof, and weight and size limitations on bundles of solid waste too large for the solid waste containers. Storage of solid waste in solid waste containers, sanitation, maintenance, and replacement of solid waste containers, schedules of routes for collection and transportation of solid waste, collection points for solid waste, collection, transportation, processing, and disposal of solid waste, processing facilities and fees for the use thereof, disposal facilities and fees for the use thereof, records of the quantity and type of waste received at processing and disposal facilities, handling of special waste such as sludge, ashes, agricultural waste, construction debris, bulky items, tires, automobiles, greases, oils, etc. Reporting requirements for contractor include the following: report semi-annually due July 15th and January 15th to the coordinator a list of households and businesses participating in the designated collection service. Report on a quarterly basis due April 15th, July 15th, October 15th, and January 15th to the coordinator all non-participating households in the mandatory collection system. Report all other necessary reports to the coordinator in order for the governing body to comply with KRS 224.43310 through KRS 224.43330. Registration of all vehicles utilized by contractors. Said rules and regulations or an accurate summary thereof shall be published 30 days prior to a hearing date for public comment. After the hearing date and public comment time has elapsed, the regulations so promulgated with any amendments thereto shall be published at least once prior to their enforcement. Copies shall be made available for public inspection in the offices of the county judge and the county court clerk. Section 9, prohibited practices. It shall be unlawful for any person to dispose of garbage, refuse, rubbish, or debris by dumping same on any premises in the county with or without the consent of the owner of the premises, own or operate an open dump or permit the open dumping of garbage, refuse, rubbish, or debris to on any property within the county. Deposit solid waste in any solid waste container other than his or her own without the consent of the owner of such container and or with the intent of avoiding payment of the service charged hereinafter provided for the solid waste collection and disposal. Fail to have solid waste collected as provided for in this ordinance, interfere in any manner with solid waste collection and transportation equipment or with solid waste collectors in the lawful performance of this duties as such, whether such equipment or the collector shall be those of the county, of those of solid waste collector operating under contract or franchise with the county. Burn solid waste as defined by KRS 224005 and KAR 63005, including the burning of solid waste in any dumpster or container used for solid waste collection. Dispose of dead animals in any container to be collected by the county of its authorized agent. Engage in the feeding of food waste to animals for commercial purposes. Dispose of solid waste at any facility or location which is not approved by the county and permitted by the Kentucky Natural Resources and Environmental Protection Council. Engage in the business of collecting, transporting, processing, or disposing of solid waste within the geographic boundaries of the county without a permit, contract, or franchise agreement from the county. Operate under an expired permit or operate after a permit has been suspended or revoked or contract or franchise agreement canceled and violate any section of this ordinance or any other rule or regulation promulgated under the authority of Section 8. Section 10, service charges. Section 10.1, fees. The fiscal court or its designee shall establish or approve service charges or fees for each dwelling unit and each commercial establishment for solid waste collection and disposal are necessary to meet all costs of operation and maintaining the solid waste management systems. All such fees, including subsequent revisions thereof, shall be paid by the resident or owner on the record of the property served and shall be paid to the county or designee at times set by the fiscal court or its designee. 10.2, delinquency. All unpaid fees shall become delinquent if payment is not received within 30 days of the notice due and may result in termination of all solid waste services provided by the county until payment is received. Delinquent bills shall bear an interest at 12% per annum until paid. The designee shall enforce collection of delinquent bills by bringing proper legal action against the owner or occupant of any dwelling unit or owner of any commercial establishment to recover any sums due, plus a reasonable attorney's fee, court costs, and any other costs involved in such collection action. 10.3, uncollected fees. All uncollected fees after judgment shall be placed on record in the locality where the property is located as any other judgment lien and shall be released when paid. Section 10.4, unoccupied residences and buildings of service and service charge shall be terminated upon presentation of satisfactory proof to the coordinator that any such dwelling or establishment is unoccupied and shall be commenced upon renewed occupancies thereof. Section 11, public nuisances. Section 11.1, notification. It shall be the duty of the coordinator to serve or cause to be served upon the owner or occupant of any premises on which there is kept or maintain any nuisance in violations of the provisions of this ordinance, and to demand the abatement of the nuisance within 7 days. 11.2, noncompliance. If a person so served does not abate the nuisance within 7 days, the county may proceed to abate such nuisance, keeping an account of the expense of the abatement. The abatement shall be charged and paid by such owner or occupant whenever a bill for such charges remain unpaid for 30 days after that has been rendered. The county may file a statement of lien claim against the property. 11.3, penalties. Any person violating any of the provisions of this ordinance or any lawful rules or regulations promulgated pursuant thereto upon conviction shall be punishable by a fine if not less than $25, no more than $500. Provided that each day's violation thereof shall be separate offense for the purpose hereof. Violators of this ordinance may be issued a citation by the county sheriff or any authorized police officer. 11.4, cost recovery. When the county must clean up and remove an opened up to ensure protection of the public health and safety, and when the reasonable party can be identified, the coordinator shall require these persons to reimburse the county for the actual cost incurred. Recoverable costs include, but are not limited to, costs for site assessment and evaluation, labor, equipment, disposal, and the legal fees. Should other means of collection prove ineffective, the county may seek such reimbursements of funds 90 days following the completion of the cleanup. Such cost recovery should not apply to property owners who are the victims of illegal dumping without their knowledge or beyond their reasonable control. Section 12, collection of solid waste convenience centers. Section 12.1, use of solid waste containers in convenience centers. Solid waste convenience centers shall be maintained at the current sites throughout the county for the convenience of the county residents. Each convenience center must be open a minimum of 16 hours per week. Solid waste may be deposited in the solid waste receptacles only in accordance with the provisions of this ordinance. All solid waste shall be deposited inside the receptacle. No solid waste may be left at the disposal site outside of the receptacle. The county may use the name of the persons found on letters, magazines, correspondence, etc. as evidence to determine the responsible party for waste left at the disposal site outside the receptacle. Commercial, industrial, and institutional solid waste may be deposited in the solid waste receptacles only with the permission of the coordinator. 12.2, bagging and binding solid waste. To the maximum extent possible, solid waste material placed into a container should be bagged or otherwise bound in order to prevent blowing or scattering of such material. 12.3, standards for use of container site. It shall be unlawful for any person to perform any of the following acts: intentionally defile, deface, destroy, or otherwise vandalize or abuse solid waste containers, container sites, or any other equipment or facilities located at the container site. Loiter and or congregate at any container site. Leave a vehicle unattended at any container site. Any vehicle left so unattended may be towed away at the owner's expense. Set or cause to set any fire in a solid waste container or at a container site. Remove any item from solid waste container excepting recyclable materials and unacceptable materials as described in section 12.8 of this ordinance. Climb on or around or inside any solid waste container. Move a solid waste container from an assigned location. Open bags or other bindings which contain solid waste either inside a container or at a container site. 12.4, restrictions by source of solid waste. The materials deposited into any convenience center shall be limited to customary items of household solid waste which otherwise comply with the provisions of this ordinance and any other applicable regulations. Such containers shall not be utilized by persons engaged in the collection of solid waste for compensation or by persons engaged in the collection of solid waste for commercial campgrounds, hotels, motels, and other forms of short-term living accommodations. In no event, however, shall this restriction be construed to deny the use of such containers to non-permanent residents of the county, provided that such persons are otherwise in compliance with the provisions of this ordinance and any other applicable regulations. 12.5, restrictions by composition of solid waste. The following materials are unacceptable, and it shall be unlawful for any person to place a solid waste containers located at the convenience centers unless such container is specifically provided for that purpose. Any of the following materials: animal waste, chemicals, concrete, cement, blocks, bricks, lumber, or other construction or demolition materials, dead animals, explosives, or other volatile substances, fire, ember, ashes, and other such fire-causing material, gasoline, oil, or any other liquid hydrocarbons, herbicides, industrial or commercial waste, except as specifically provided for. Liquid other than those contained in customary household waste, metal, wire in large amounts, motor vehicles, nuclear or radioactive waste, pathological waste, pesticides, poisons, road construction materials, including but not limited to asphalt, gravel, etc., sludge of semi-solid fluids, tree stumps or logs, toxic waste. 12.6, collection frequency. Any person providing solid waste collection or transportation service shall provide said services at a minimum frequency of at least once per week, with the exception of holidays and natural calamities, to protect the public health. Section 13, bonds. Bonds are suggested to ensure the performance of all collectors or transporters of solid waste and the operators or processing of disposal facilities. The amount and types should be determined by the county. Types of bonds which should be considered are performance bonds and payment bonds. Section 14, savings clause. Nothing in this ordinance shall be deemed to affect, modify, amend, or repeal any provision of any ordinance administered by the Martin County Health Department or other department, board, commission, or agency of Martin County. Section 15, severability clause. The provisions of this ordinance are severable, and if any provisions or part thereof shall be held invalid or unconstitutional or inapplicable to any person or circumstance, such invalidity, unconstitutionality, or inapplicability shall not affect or impair the remaining provisions of this ordinance. Man. My eyes are crossed.
Hey, I was late, could you read it again?
No. I can't see you right now.
Well, what that's talking about is if they have an open dump or an illegal dump on their property and the county has to clean it up. That's all that's
This over here on page 22, it's got that we can put a lien on people's property.
Yeah,
If
that's
they don't
if
pay
we
the
have to
bill.
go in and clean it up.
No, if they just don't pay the bill.
The bill section,
That's
On
right,
page 22,
that's public nuisance in section 11. Basically, it's if they have an open dump in their yard and they won't clean it up and the county has to clean it up. That's what that is. It's not about the bill.
the bill is section 10.
okay,
and
well,
that's 10.
still get that there made, you know. I figure if we still put lien on property, bring it to court and make it pay, put the lien on the property.
Well, that's just saying that the county had to go in and clean it up.
We already got that.
We already have that. I mean, it's the same
I thought we
language.
had that, but I didn't know, so.
It's the same
I'm
language.
just making sure.
I'm just saying, I mean,
Well, that is the first reading, guys. We don't take a vote today. Now, let's go to the date of advertisement. We can put it in 2 papers. It's going to go in the 8th and the 15th. We're going to have our next second reading on the 16th. Am I correct on that?
I'm not certain if it has to be at the second reading, has to be the next regularly scheduled fiscal court meeting.
We can set it after it's advertised 7 to 21 days.
I just have to put in the summary that we send to the papers, what day that the next reading is
April
going to
the
be.
16th at 4 o'clock. And at that time.
okay, so are we gonna have are we gonna have a special meeting for that?
Yes,
On the
sir.
16th, and then we'll still have our regular meeting
No.
on the 30th, on
We're
the,
going to move it up to the 30th.
The regular meeting?
Because we'll want to advertise the franchise agreement for 2 weeks, two papers. Like on the 22nd and the 29th, and open them on the 30th.
okay.
So we need to advertise at the regular meeting. We'll leave it.
The second reading of this ordinance will be at 4 o'clock on April 16th.
16th, and then the.
And at that time, we will approve the franchise agreement. And he'll advertise the 22nd and the 29th, and move the regular meeting from the 23rd to the 30th. Motion to adjourn.
Motion.
Second. All in favor?
Yes.